Thank you, ladies and gentlemen. Thank you for coming. Let me start by introducing myself. My name is Simon Mizrahi. I am the Vice President for Technology and Corporate Services here at the African Development Bank. The President has asked to share with you, I think, some important comments and to share with you his deepest regrets. Unfortunately, he's tied up with the the Governor's Dialogue that still hasn't finished, and has asked me to share with you some important comments that he wanted to convey to all of you. Now, before I do that, let me just say that how importantly the President feels about the conversation we're about to have. I'm particularly glad to be here. I know a lot of the people sitting around the table, they're all friends and colleagues, so I'm particularly pleased to be here to make these comments on his behalf. So, first of all, what I'd like to do is really thank all of you for coming to this session. It's a very important session. It's a very meaningful session. Amongst other things, what I would like to do is to discuss, and it aims to better discuss and understand the fundamental roles of the different oversight organs that we have here at the bank. And let me say from the very outset that the bank is a very transparent organization. Last year, the bank was rated, in fact, as the most transparent development organization in the world by Publish What You Fund. And just speaking on my behalf for a second, I do know one or two things about that because I was in charge of driving this exercise that led to this particularly useful transparency. So I just want to signal how this is important to me personally and not only to the President of the African Development Bank. So coming back to the President's comments, I think the important message in making this, in saying this, is that, you know, we do what we say and we say what we do. Or to use the language of the President, we report on what we do and we do what we report. Now, let me now turn to the important role of the oversight bodies, and I'd like to start in particular with the special role of the administrative tribunal. I think, as you know, the tribunal is mandated to be the recourse mechanism to deal with issues of staff and administrative issues. It is made up, as you know, of justices and former chief justices of countries, and their adjudications or ruling are absolutely mandatory and cannot be appealed. Let me move on to the Sanctions Commissioner and the Sanctions Appeal Board. They deal with matters concerning the sanctions imposed on companies for violating procurement rules and corrupt practices. The Ethics Unit deals with staff ethical issues to ensure that all staff adhere to ethical behaviors, that they adhere to honesty, that they make sure that we, to principles of integrity and professional conduct. The independent recourse mechanism that is represented here by Mr. David Simpson deals with all issues of complaints by individuals, communities, entities, and organizations that are affected by the bank-financed project. As a bank, we do all we can to ensure that our projects, all of our projects, each and every one of our projects, have positive impact on the lives of people and the population and communities. But sometimes we have challenges with project-affected persons which are displaced, for example, by projects, matters of due and fair compensation, as well as ensuring that the bank adheres to the highest standards of social, environmental, and governance standards. So let me be very clear. The bank has zero tolerance when it comes to sexual abuse and harassment across any of the projects. Zero tolerance for sexual harassment. We are an accountable and responsible bank. We work to make sure that all voices are heard and respected. And finally, our Integrity and Anti-Corruption Department, or PIAC as we like to call it, is our internal independent investigation department into all matters that have to do with staff misconduct as well as corruption or sanctionable practices by companies on bank projects. Now, I'm very proud of all our independent oversight institutions, their professionalisms, and upholding the honor, integrity, and accountability of the bank to the rule of law and global best practices. This is the first time that the independent organs of the bank would be seen to discuss at a public event program of the bank like this one, and first time ever at the meeting of the bank. And this was, and I'm quoting the president, this was my decision. I discussed with all our esteemed justices that we should have an open discussion at the annual meetings, and I must say this is the first time ever that this is done by any financial institution. I think it's another mark and strong signal of the African Development Bank's transparency. So in conclusion, I'd like to invite you all to enjoy your interaction, discussion with our independent oversight body. Thank you very much to all. This now concludes the President's comments. Thank you very much. Over to you, Khalidou. Merci à toi.
All right, so we're going to start. I am going to be moderating this session. My name is Khalidou Gadio. I'm currently co-chair of US Africa practice at the international law firm of DLA Piper, based in Washington, DC. But I think some of you may know I was also former general counsel of the African Development Bank for quite some years. And I did participate in the establishment of some, not all, but some of the institutions that we are going to be discussing with. So this is going to happen. I'm gonna have the members, the panelists introduce themselves, and then we'll start the debate, and eventually at the end, I may give you the opportunity to ask one or two questions. Not too much, because they are already quite busy. So the Vice President made it quite clear what it is about is something very important. These are what they call independent accountability mechanism or independent oversight. Essentially, it's a number of institutions that are independent from the board of directors, from the president. They make a decision independently. So that is a sign of transparency, I think, that Simon was mentioning. So it is very, very important. So without much ado, we're going to start. I'm going to have them introduce themselves, and we're going to start from there. So, Mr. President, I would like you to introduce yourself, where you're from, and what you do for the bank.
Thank you very much, Mr. Coordinator. Thank you very much. I am moderator, I'm sorry. I am Epuli Alo Matthias, a judge in Cameroon, and I'm president of the bank for now. The tribunal. The tribunal of the bank. I'm sorry.
No, it's okay.
I'm so proud of the bank.
Next year maybe.
Candidature?
Next year you can
No,
be a candidate.
thanks.
Yeah, but not this year.
Actually, you'll excuse me. I'm overwhelmed by the idea of the bank. I consider it as a legacy, an inheritance left to us, particularly in Africa, by our forefathers. It was an extremely well thought out project, and it was the kind of thing a responsible parent does to the family. So I'm particularly happy with the bank.
Thank
And
you.
we'll do
Mr. President.
anything to help it to stand properly.
Thank you, Mr. President. Justice Theron, can you introduce yourself?
Yes, good afternoon, Mr. Gadio. Good afternoon, everybody here. My name is Leona Theron. I'm from South Africa. I am a judge on the Constitutional Court of South Africa. I am a judge on the Administrative Tribunal and past president of the tribunal. And I'm very happy to be here. Thank you.
Justice Wanjala and Commissioner for the Sanctions.
Yes. Thank you very much. My name is Mokino Wanjala. I come from Kenya. I live and work in Nairobi. So let me also welcome you to Nairobi. I'm a judge of the Supreme Court of Kenya, and I'm currently serving as the Sanctions Commissioner of the bank, the Sanctions Office of the bank. I'm sure in a couple of minutes we'll be talking about what it does. Thank you very much.
Barrister Nkafu,
Yes.
can you introduce yourself?
Thank you, Mr. Moderator. I'm Julius Nkafu. I am a barrister, Supreme Court of England and Wales and of Cameroon. I am I'm a member of the Sanctions Appeals Board, and I'm delighted to be here today and most honored to be a member of this panel.
David Simpson, could you introduce yourself?
Yes, thank you, Chair, and good afternoon to everyone. I guess when you say you're honored to be here, I'm wondering why I am here with such an esteemed group of justices. My name is David Simpson. I am a director of the Independent Recourse Mechanism. I've had the honor and privilege of working with a number of other MDBs as well as think tanks in the area of accountability. So there's maybe a theme passing there. And I guess I work at enhancing accountability towards sustainable development.
Thank you very much. So, you see, this session is very interesting. So, the bank has all these ladies and gentlemen, each one of them representing one of the independent accountability mechanism. But I'm going to tell you something that probably you know, but I'm going to emphasize it. You see, the bank has even more institutions that in one way or the other can be characterized as part of this apparatus. For instance, we have, of course, administrative tribunal, we have the Sanctions Appeals Board, we have independent evaluation. They're not here, but they play the same role. I mean, they're all looking over the shoulder of the administration. We have the Office of the Ethics. They're not here. We have PIAC, which is also to a large degree an independent department in the bank. I would forget the legal department, the general counsel, is also independent because the general counsel, review and issue independent legal opinion to the board of governors, to the board of directors, to the president and the management. And we also have internal audit. You know what? They do roughly the same thing. They look into the shoulder of the administration. We have even risk management. They also have a very independent role, and we have the independent review mechanism. So there are 9 of them. I'm going to ask a question. Is it too much? Mr. President, what do you think?
Well, it depends on how the functions dovetail into each other. It's like you have warders in a country, you have policemen, you have soldiers, you have sailors, and so on and so forth. All of them come together to make up the network that takes care of public peace and security. Yes, so it depends on how they dovetail and how, I mean, if there is duplication, then they need to be sized down. The numbers need to be reduced. But if there isn't duplication, then I think it would be all right. Secondly, the experience I've had is that down the years, the number of solicitations we're having at the tribunal is reducing. I don't know whether it's because of the mechanisms, the first line mechanisms, or because of the tribunal, or it's just because the people are a different type of people.
Thank you, Mr. President. We will have an opportunity to come back in detail about working of the tribunal. But I'm going to jump to David. You are, of course, independent, but I think you are permanently inside the bank. Am I right? So what do you think? Do you think like there are so many eyes looking over the shoulders of the staff?
How typical of a lawyer to take a very negative view of that, no? Let me take the other side of things, because I think what I would do, and one of the things that we do in terms of a theory of change, even for our department, is looking at where do we add value, rather than seeing this as a negative aspect of, checks aspect. And one of the key elements that we do is one about a value added of learning, institutional learning, what do we bring back? And I imagine that's probably a core that runs through all of the work that we all do here. It's not just simply end of pipe decision. If it is, then we're missing a big opportunity, but it's how can we take that and improve projects going forward. So I wouldn't necessarily say it's an issue of like too many or too little. Accountability is an essential currency, I think, that we're all seeking. And it doesn't start and stop with this group here either, by the way. I think the bank itself has all sorts of elements within itself of self-checking, different controls throughout the process. They're all part of that quality process of building something in that area.
Thank you. Justice Theron, what's your take on this question?
I think it's important for the different bodies to complement each other. And there should not be a duplication of functions. I don't know all the detailed functions of the various bodies, and so it's difficult to say if there is overlap. What I do know is that the tribunal is there to deal with disputes between employees, former employees, and the bank. And PIAC, for example, is the internal investigative unit to determine if there's been any corrupt practices or practices that have adversely affected the bank. The internal recourse mechanism and bodies have a different role and responsibility. I think in order to answer that question properly, if the bank wants to consider whether there is an overlap between the various bodies, I think then there would need to be some kind of audit of what their functions are, and if there is a duplication of functions, you may even find that there might be a vacuum.
Wow. Chisu Wanjala, give us your perspective on that question.
I agree with my colleagues who have spoken. Looking at the bank, this is a huge institution. It is continental, is international, and it caters to various constituencies. It has a huge regional presence throughout Africa. And each of these accountability mechanisms have been assigned specific jurisdictional roles. And I don't see, for the 4 years now that I've served as the sanctions commissioner, I've yet to perceive any overlaps. between, for example, the office that I occupy and, for example, the Sanctions Appeals Board, the Audit Office, the Tribunal. Each of these is very carefully crafted to carry out a jurisdictional oversight role. So to me, my short take is that there are not too many. In fact, they're just necessary. That's my take.
You, Barrister, what's your opinion on?
I think my fellow panelists have said a lot that I agree with, but I would say two things. There's nothing wrong with extra safety. It's always important to be safe than sorry. The old English adage that says belt and braces. So you put on a belt and then you put on braces so that if the belts fall off, if the belt snaps, the braces will still hold your trousers, so you'll be fine. So safety is a good thing, but if there would be instances where there will be sense of duplication, then I think that would need to be, that has to be reviewed so that things are all streamlined. But finally, I would say that an institution, like my brother, Justice Ojala just said, is massive, it's very big, and it's got immunities. And to get this immunity, you're saying that I've got all the necessary structures internally within me to deal with all potential problems, to deal with any problem that can arise. So we don't need national courts. And you have this, it's not only having it, but you have to keep it. And to keep it, there's need for that constant checks and control all the time. So whether they're too many or too few, it is only a matter of constant review, but there is need for extra safety.
Thank you very much. So let me ask the president of the tribunal, what is it in your opinion, the importance of the tribunal in an international organization such as the African Development Bank?
Thank you very much for letting me have the microphone again. You see, the bank initially did not have a tribunal, an administrative tribunal. And as time went on, it was found that people were suffocating. They would deal up to the internal recourse mechanisms level, and thereafter they had no recourse whatever, because the bank has absolute immunity. Not only immunity of execution of judgments, but also immunity in filing cases against it. So what happens if you are through with the internal recourse mechanisms and you are not still satisfied? What do? You cannot go to the local court, that's the non-bank court, because the bank would not even receive your writ. But you'll be frustrated. And every human being is entitled to his day in court, to put it briefly. Consequently, the tribunal has to be there, to be the last post at which everything has to be sorted out. And it's, from my experience, also serving as a beacon that helps to direct the whole bank as to what is right to do and what is not right to do. It is the right of every human being to have access to a properly constituted law court and to present his case. If you don't have the tribunal, then you'll be disenfranchising, disadvantaging a lot of people. Because the bank is, as has been said, is a very big organization. It has a large number of people working there. And not only in Abidjan, all over the place. Recently, a regional office was opened in Yaoundé for Central Africa. And it's a huge edifice also. So we absolutely need an administrative tribunal at all international organizations that have immunity in order that justice may not only be done because the other recourse mechanisms work behind closed doors most of the time, but must also be seen to be done, and it can only be seen to be done before the tribunal, which holds public hearings. Thank you very much.
There's an interference, like some kind of music. Anyway, Mr. President, I think you explained really clearly the importance of the tribunal. But what makes it special? Obviously, it takes a decision. Why those decisions are so important? Are they, for instance, can the management decide they don't like your decision and move on, do something else, or what is it? Because after all, I mean, the president is the chief of staff. He recruit and fire whoever he wants. What is special about the decision of the tribunal?
What's special is that it's a tribunal, first of all. And you don't play around with decisions of tribunals or courts of law. But more specifically, in the case of the bank, I have no experience, I don't have any experience of a decision being impugned by the bank authority, by the bank, the president or any of his officers working with him. And so, as I said, it's for that reason I said that the bank's decisions serve as a beacon for all the court, for the entire bank, beginning from the president down. And the bank, tribunal has its own statute. It has its statute, it has its rules of procedure, distinct from everything and anything that is within the bank.
Thank you. Thank you. I think it is a beautiful institution, and unlike court and tribunal, who can actually enforce the decision, you don't have any policeman to enforce your decision. Basically, you render your opinion, and the administration decide to comply with, because in the national court, the judge doesn't need the government. He can direct the police to enforce the decision. So this is a wonderful. Let me ask you, indeed, you are there to protect staff members and in the relationship with the direction and the management of the bank. Now, there's something that is very noticeable in all international organizations, is that they don't have only staff members. They have all kinds of people who work for this institution. And they are sometimes, they're called like consultants. And sometimes they're at the same level in terms of responsibility. They come to the office every day and they are subject to the rule and the regulation of the bank. And yet, if I'm not mistaken, they don't have access to your tribunal. Is it okay?
The short answer is that any and everybody who works for the bank should have access to the independent administrative tribunal that we are. There is certainly a growing tendency worldwide of big organizations, especially international organizations, moving towards contractualization of jobs. They no longer need or want to keep people who will be there for until retirement and perhaps a little above. They want to take you for 2-3 years, and thereafter they send you away, no benefits, no insurance, nothing, nothing, nothing. I don't think that's a very good trend. I am not within the administrative structures of the bank. I don't know what percentage of workers of the bank constitute, what do they do? In French we call contractual. Employed as contract holders. Certainly there is something that those organizations do. They add you a few shillings on top of what another person who is a permanent member of the staff would earn. But the benefits go away. And it's when you have done all the work for them that you need those benefits. You can no longer function as before. You've grown old, you are tired, and you need your health insurance. It's supposed to be a reward for a good job done. And it's done not just for yourself, it's done for the organization, and it's done for mankind. We want to make the world a better place for everybody.
The bank may say, well, they are not recruited on the same basis. They don't go through the same screening process. So that's why maybe there is some level of differentiation. But nonetheless, I think your point is well taken. And let me just move on a little bit to ask Justice Stroman, because you're basically the dean of the tribunal. And tell us a little bit what has been your experience, because you have been not only the tribunal, you've actually shared being the president of the tribunal. So you really have a long experience. Tell us a little bit what has been your experience.
Thank you, Mr. Gadio. I've been on the tribunal, I think, 10 years or just over 10 years. And I came as quite wet behind the ears. And I'd like to believe that I've grown through this experience. And my experience with the tribunal has been positive. I found that I joined an institution that was credible. It was credible, it was legitimate, it was independent. And that was due to the way it was set up by its forefathers, which I believe one might be you. And the relationship between the bank, the management of the bank, and the tribunal. Or should I actually say that once the judges are appointed and the board and the management's involved in that, there is no relationship. So the judges are completely independent. I must also say that in my experience, the management has been very supportive of the tribunal. There's been a good open relations between the secretariat and the management, which prevents the judges from having to interact directly with the board and to keep that distance. So if there's any requests that we have as the judges of the tribunal, requests from management that would make our work more efficient, make the tribunal more competent, we relay those to the secretariat. And the secretariat in turn consults with management. And I must also say that all the requests that we've made have been positively received. And I think as an institution on the continent, the tribunal is a credible institution. It's an institution that is highly regarded. And it's the employees as well also have, as I believe, incredible faith in the integrity of the tribunal. And there's no mechanism for the tribunal to enforce its orders. But because of the mutual respect that the management has for the tribunal, and that the management recognizes the importance of the role of the tribunal, that they enforce the orders out of respect for the tribunal and out of respect for processes and for the rule of law, which bodes well for this institution. And I would say one of the reasons why it has been ranked so highly in terms of governance in the world.
But after 10 years, you must have seen some challenges. So it couldn't be all perfect or some difficulty. Could you elaborate if, in your opinion, there have been some challenges, some issues that you think going forward could be addressed?
Yes, definitely there's challenges. We don't live in a perfect world. We aim to achieve the best. We aim for high standards, but there will always be challenges. One of the challenges that the tribunal experiences is the equality of arms between the bank and staff members. The bank is always legally represented. Staff members are not always legally represented. There are times, well, there are some who cannot afford legal representation and come to the tribunal fighting their own cases. And there's definitely an inequality in situations like that. I do believe that some international organizations have now looked at something like what we call legal aid in the domestic sphere. And perhaps that is something going forward that management of the bank can look at. A criticism generally of administrative tribunals is that there's no uniform rules or procedure. It's each tribunal has separate rules that govern that particular tribunal. And with the burgeoning of administrative tribunals, it can lead, or if there was uniformity in terms of rules, in terms of procedures, it will also lead to more uniformity in the judgments. And often we say, well, those rules are different, so this case is different. So we distinguish more. And sometimes the people that we serve, especially the staff members, don't understand that if they had to go to another tribunal, perhaps they would get more compensation or be successful. And so, and it's also about educating staff. I cannot recall in the 10 years that I've been here that I know you'll speak of is it city hall meetings or things like that, where the judges have just broadly addressed staff as to how the tribunal works, the mechanisms, and maybe our deliberation processes, and what governs us in reaching conclusions. Something that also concerns me personally is, how do we know that we are effective as a tribunal? How do we know that we are relevant? Times are constantly changing. And is the tribunal addressing the changes? What is the tribunal proactive and even as regards of the situation of consultants? What is the tribunal doing, or do we just sit and wait, or are we proactive? Do we make suggestions? And how do we measure ourselves and our performance? Obviously, one way is to see if our judgments are cited in other tribunals. I must confess, I've been too scared to look, to see. but Mr. DeLater tells us that he often meets his counterparts who say they do have regard to our judgments. One thing that's positive is that when new judges are appointed, they have an opportunity to sit as observers first. which you didn't allow me to do when I came. So I was thrown into the deep water, but I think that's very good because it makes the judges more effective in the long run to have that kind of basis and introduction and induction as to how the tribunal works. The other challenge that I see is that the Secretariat has a small staff, very, very competent staff. But there should be a creation for upward mobility for the staff within the tribunal. Because if there isn't that, then they will soon be looking elsewhere. And if they do, it will affect the delivery of the work and the standard of the work within the tribunal. Thank you.
Thank you very much. I hope the representative of senior management are listening, because these are really extraordinary comments by Justice Theron, who's been here for 10 years. And she explained really how wonderful the tribunal is, but also the concerns. And these, I hope, my friend Simon, you will convey to the president, because these are fundamental challenges that can be addressed by the management. I mean, if staff members don't have the means to represent themselves, there should be some way. I mean, it's a part of due process. Everybody has to be able to be represented. So it is also true a tribunal can function only as much as it has the support staff, you know, because the judges are not resident. So they need a staff that support them. So this is really wonderful. But before I let you go, I still have another question. In the statute of the tribunal, it is stated that you are empowered to provide to the bank, at its request, advisory opinion. But I understand that you have never been asked, or rarely, your views on matters that are of concern to the bank. That has some legal implication. Why is it so?
Perhaps we should call Vice President Simon to answer that question. If I can take a guess, I think it might be, I think it's possible. But I also think rules would need to be developed as to how that process can be used. We have it in the statute, but I don't think that flesh has been given to it. And what do I mean by that? How would it work? Would the board then just send a legal question to the tribunal? Would there be a public hearing? Would lawyers from the bank be called upon to make submissions in respect of that opinion that the board is seeking? Because you must remember, as judges, we ourselves, we rely on the presentations that are made before us. We rely on the issues being defined by the parties who come to us. And if we only hear one side, and we only hear from the board, we might not get a full picture, and we might not be in a position to give an opinion that is worth the paper that it's written on. So we might need to develop rules where we can invite amici or friends who would make submission or who would have an interest in, because perhaps this is an area that the Board of Governors could use if they want to introduce a new policy or a new regulation, or perhaps even amend an existing one. And obviously it may affect staff, it may affect operations, and if there is a staff association that may be affected, then maybe they can be invited to present from their side how the proposal might influence them positively, negatively. And as judges, we can't draw from our own knowledge about how a proposal from the board would impact on the bank, on its staff, and on its operations. We would need submissions and evidence to be placed before us. So perhaps the fact that that provision hasn't been used is because the rules haven't been fleshed out to see how it will work.
Let me just say something in French. So, en droit civil, les juges ne peuvent pas se saisir d'eux-mêmes d'un dossier. Il faut qu'il soit saisi. So, in short, it means that judges cannot go, assert jurisdiction of a matter that has not been brought before them. So that means essentially what you're saying is absolutely right. You cannot interfere if you're not asked an opinion. But let me ask the last question. Because it's really interesting what you said. I remember when the bank was considering setting up the tribunal, there was one provision that exists in one of the administrative tribunal of sister institution, which we decided not to follow, which is that, for instance, at the IMF, the tribunal has the power to review the decision of the board. It's very important. But we decided not to put it for the ADB. Do you think we made a mistake?
Well, if you give me time to consider the question and research and look at other institutions and to see how it has worked in other institutions or if it has not worked, I might be able to answer. But if you present me with that question and something I've not considered, it will be very difficult for me to answer, or maybe I'm being diplomatic.
That's that's a very fair answer. Let me move to barrister. Have you been busy?
Me?
Yes. Your institution.
All right.
The Sanctions Appeals Board.
Thank you so much. Yes, I think it may be helpful if I just set the scene. My position as a Sanctions Appeal Board member. You were part of the architecture since 2012, putting the structure in place.
Guilty as charged.
And since then, you'd know that it is a two-tier adjudicative procedure that we follow as by way of resolving disputes. So you have the first tier, my brother Justice Wajana, and the second tier, which is the Sanctions Appeals Board. We sit 3 in number at a time, and our decisions are very, very independent of the bank. And we hear appeals from up from the first tier. And we have, since its inception, dealt with 13 contested cases. So it all starts from the Department of Integrity, who will send up matters to the first tier, and then the first tier will send it up to us. So the number of decisions that or cases that we do depends solely on how many cases leave PIAC to the first tier and then up to us, bearing in mind that during the process, an appellant or either side could decide to request for settlement, to settle matters. So, yeah, but I'm just saying.
Did you say only 13?
Yes, 13 contested cases that we've
Does it mean that the commissioner is doing such a wonderful job that the people don't feel the necessary to go to you? I'm putting him on a little bit on. I'm gonna ask him some tough question later. But 13 after how many years?
Yeah, well, 2012, from the time that was
more than 12 years.
Yes, more than 12.
That's not much.
But it's not a lot, if you come to think about it. That's why I said that some of these cases have been settled down to line. But we have not been sleeping while we were not doing cases. We delve into some policy issues, which I thought are issues that would be within our jurisdiction to look at them, like rules of procedure.
I was going to ask you about some of the things that you think could be changed and improved on the procedures. I am aware that there are some changes that have in the way of being introduced or have already been introduced, which are considered to be favorable to people who appear before which is that to lengthen the statute or the time within which
the limitation period for appealing. Yes, I think sometime back from 2018, 2017, 2018, we kind of thought that the limitation period that the African Development Bank applied was very restrictive, 25 days. This was way below what the other sister institutions like the World Bank, the Inter-American Development Bank, the European Bank of Development and Reconstruction, or Reconstruction and Development, and the Asian Development Bank. They all had 60 days, and I think the lowest was the European Bank for Reconstruction and Development, which had 45, but all of them significantly above. And bearing in mind that in 2010, all these sisters institutions came together and signed agreements on cross-barring, which means that if one person is sanctioned above a certain level in one area region, one sister organization, it goes across the board. Then giving that one section will be having a limitation period of just 25 days as opposed to the others who had 60 days. We thought it was hugely unfair. But it was kind of an uphill struggle for us. We thought initially it would have been something which we will just say, okay, we recommend that this limitation period moves from 25 days to 60. But eventually the president was sympathetic with that, but it took about 2-3 years.
But my question is actually legally, did you need the approval of the president? Isn't a matter of procedure? Because if that issue was before the tribunal, they would have handled it internally.
Yes.
It's considered as a matter of rules of procedure, which is within your jurisdiction. So why did you need the president to opine on whether you need to extend the period from 25 to 60? After all, the other institutions have, some of them even have 90 days.
Yes. So, well, I think that is one of the things that if we were given an opportunity to request another change, we would, because there's a blur line between policy and things that the tribunal has powers to just recommend and it works. If we had that power given to us, we would have done this thing within months and it would have been done and dusted. But because it appeared to be a policy.
Are you sure you don't have that power?
Well, it is not. If it's not written, it hasn't been given. So it is not in our rules that we can do that. And that is why we went the way we went to. And it was quite a struggle. And which brings me to a point to your initial question about the multitude of different organs working together. If there is no clear line about who is doing what, looks like a man who gets married to 10 wives, and each wife thinking that this other wife is going to cook, the other one thinking that, and the man ends up sleeping hungry because each woman is thinking that the other one is going to cook. So that is one of the problems. It wasn't clear to us that who was actually responsible for doing that. So, but when we initiated the proceedings to get this change, it was kind of an uphill struggle in a way because, and it took us 2 years, cut a long story short. But thank God that has been resolved. So one of the changes we'll be recommending is that the tribunal should be allowed to exercise its jurisdiction for procedural matters to say, hey, this is a simple thing that could be done within, it doesn't have to go through the whole system for a simple thing like that.
I believe it is good to make a distinction between substantive issues that are a matter of policy, for which, of course, the bank management and the board should be involved working with General Counsel, and the issues which are traditionally given the authority of any body and organ like you to in the rules of procedures. So if it wasn't done, mea culpa. But I think it is absolutely critical that as a sanctions appeals board, that you adopt your own rules of procedures that may include issues such as the one that we mentioned. But let me ask you another more complicated question.
Complicated?
Complicated or controversial. The issues of settlement.
Yes.
Now, I recall initially the board was not necessarily favorable. So in the management, we made a strong case that we should have what the World Bank has. But then after it started, there was a view, I'm not necessarily sure it is true or not, because I will ask indirectly the commissioner. After all, he is supposed to be approving those settlements. So there was a view that there were too many settlements. And that may be the reason why you have only 13 cases before you. Because most cases are settled. Is it a good thing?
Well, I think it's wrong. is not a good thing. Uh, Settlements should really be in very, very exceptional cases. It shouldn't be the rule. There should be very tiny minority of cases that can be settled. And even though that be the case, there should be an independent, a separate person, an independent person to initiate that discussion of settlement, i.e., after the investigators have conducted their investigations, they should deliver, they should just transmit the findings to an independent third party, providing that third party with all the evidence they have gathered in the process. When I say all the evidence, I mean the evidence that show that the accuser might have committed a sanctionable practice, as well as evidence which show that the accuser might not have committed a sanctionable practice. So it will be the third party who will look at all the evidence and decide which one should just a decision be taken, which will maybe generate an appeal.
But I have to say that third party is sitting next to you.
Yes, I'm saying. I wasn't going to name names because I know he's going to use his mouth.
So then the system is fine.
Well, I don't know how much he will have to tell us how he
I'm putting
gets
on the spot voluntarily.
Yeah,
provocative.
but
So because you decided it was not good, does it mean that, in your opinion, they probably not the principle of settlement, but maybe how it was used?
Yes, I think that, I think you put this in place. I'm delighted today because I'm sitting and I've been asked questions by somebody who is the architect of it, and so I would have just put the questions back to you. But because I'm trying to be polite, I would not do that. But just out of curiosity, what do you think about it?
I was given the position of a moderator, which means I ask the question, I don't answer the question. That's what journalists say.
All right, okay.
Answer the question.
All right, thank you so much. I think I agree with you. You're there to ask questions. But I think overall, the idea of settlement, like I said, should really be for the small minority of cases. Because there are entities who would have come to source fundings from the bank, which owe this fiduciary duty to the stakeholders to protect money and that ensure that money that they are in charge of the funds are being applied as they are desired to be applied. So it is unbelievable that for its term of existence, there are no entities that have not come with the sole objective of trying their luck to undermine the systems in place. Those sort of entities don't have any room for negotiation, no room for settlement. Those ones are dealt with accordingly and excluded completely. There are other entities that have committed, some breaches, some of them intentional, some of them not. Some of them are breaches that could be, some of them are things that could be rehabilitated. Those ones should be rehabilitated and let carry on with business. But some of them that are clearly seen to have undermined to the extent that if something is not done, they would have just gone with it. In fact, they'll get money and just disappear. Those ones, there's no need, to my mind, for any discussions with a view to settle.
You're not off the hook yet, because I have even more complicated question. According to the rules and the policies, there is an assumption that, not an assumption, actually it's written quite clearly that you cannot prosecute government officials. Does it mean they never commit corrupt practices, or you just don't have a jurisdiction over them? I mean, is it, after all, we know in the bank, procurement procedures are handled by the government, not the bank. Bank provides opinion approving or disapproving, but the bank doesn't conduct the procurement. So the people who conduct procurement are either the private sector or, for the 80% of cases, government officials. So why are you why can't you handle issues when there is a suspicion that government officials are involved?
That's a very good question, and honestly, it's a typical example of a question that I would have thrown back to you, but you warned me earlier on that you're a moderator and you're here to ask questions. What I can say in relation to that is that when there is an allegation or assertion that a government official is involved in a dodgy practice vis-a-vis the bank, there is referral. The bank refers that individual to its national authority to deal with in good faith. But we must know that the bank operates in the jurisdictions of its members. And there are issues of sovereignty, there are issues of diplomatic relationship. And remember that the bank also works in partnership with the various governments to develop their goals and their programs. So trying to want to prosecute government officials could be seen as infringing on its sovereignty and also undermining the partnership relationship. But I wouldn't like to say, it's not good to chastise your shareholder, but I'll pack that for the moment. But this practice is not unique to the African Development Bank. It is the same practice that goes on the World Bank, the European Bank, the Asian Development Bank, and Intercontinental, Inter-American Development Bank across the board. So that is basically why I would say that they are not. But hopefully, the national authorities, relevant national authorities, when these cases are referred to them, they do the needful, namely investigate and punish the wrongdoer according to their laws.
Thank you very much. I think I need to move on because you've answered a lot of questions and very exhaustively, and I appreciate that. Let me actually go to the person who has the hammer. Justice Wangala. So explain to us basically the process of the sanction, because after all, you're the one who has the hammer or the sword, boom, boom. So tell us, how does it work?
Thank you very much. As its name suggests, the sanctions office or the sanctions commissioner is appointed with the objective of sanctioning or punishing those entities that have been adjudged to have been involved in sanctionable practices. This is how it works, just briefly. That office, the Sanctions Commissioner, is appointed by the Board of Directors upon the recommendation of the President of the bank for an initial term of 3 years. Then there is also what we call the alternate Sanctions Commissioner. Perhaps you'll give me an opportunity later to talk about that structural defect. Then the Sanctions Commissioner can be reappointed for a further non-renewable 3 years. So I and my colleague, Professor Nguyeko from Burundi, were appointed Sanctions Commissioners in 2019, and our term was renewed in 2022, September. So this is how it works. The Sanctions Office depends almost entirely on the Integrity and Anti-Corruption Department of the bank, the investigative arm, and I'm happy today we have the director. It is called PIAC, P-I-S-C, because I think it's housed in the presidency. And it is that investigative unit that investigates allegations of sanctionable practices that entities or companies that may have been funded by the bank to determine whether, in fact, in that process, they have committed one or two or more of the sanctionable practices. And we are talking about corruption, allegations of corruption, fraud, collusion, coercion, and obstruction. Those 5 limbs Those are the sanctionable practices. Once the PIAC is satisfied that on the basis of its investigations, it is likely that the entity which has been investigated has committed a sanctionable practice, then it sends to the sanctions office what we call the FOSP, Findings of Sanctionable Practices. Then the office processes that note and forwards this to the sanctions commissioner, who then has to evaluate on the basis of the allegations and the evidence and the materials, documents that have been forwarded in support of that FOSP, to determine whether the preponderance of the evidence points to the fact that this entity is more likely than not to have engaged in a sanctionable practice.
Just let me interrupt you.
Yes.
Just a little bit. I'm going to have 3 more questions, and I would like to pose them at the same time so that you can decide how you want to address them.
Okay.
I would like to be, if you could elaborate a little bit why the standard of proof is preponderance of evidence, when in fact what we're attacking is something that is usually in our national law considered as a crime, whereby the standard of proof is much higher. But I have other questions, so I want you to describe also how many types of sanctions you take.
Yes.
And then obviously, if you face challenges, and then if you have some suggestion in going forward, how to improve it, and then basically, what are lessons drawn? Basically, if you can take it any way you want, but these are the follow-up questions.
Thank you. Thank you.
Go ahead.
At least I'll not go through what my colleague has gone through, because you appear to be fairly fair to me.
I have to defer. You are Chief Justice of Kenya. I have to be careful. I'm still in Kenya. But he's a barrister. He's a colleague of mine. I can tease him a little bit.
So quite briefly, thank you. Thank you very much for that. Quite briefly, once the Sanctions Commissioner makes a decision to the effect that on the preponderance of evidence, a sanctionable practice has been committed, then he issues a notice of sanctions proceedings, and that notice reproduces those allegations and is served on the respondent company, and a time is given. Then the third process is the commissioner then makes a decision based on his evaluation of the evidence. Thereafter, in that decision, he shall issue sanctions. And I must point out that the decision of the sanctions commissioner, unless appealed, is final, and it is actually self-executing. There is no escape from that. No wonder you said that the sanctions commissioner is a man or woman who wields the sword or hammer. But these are the types of sanctions that may be issued by the commissioner. One, we have a letter of reprimand. Then the negotiated settlement agreements.
Which apparently you approve with some degree of
well,
understanding.
I have only presided over the approval of 4 negotiated settlement agreements, not that many. But I think those ones that I approved are not bad. I think negotiated settlement agreements are not that bad, because the sanctions process is not intended to place bulwarks in the process of the bank lending, and then the entities using the money for development. Is actually, and now that goes to the question you asked, why preponderance of the evidence are not perhaps beyond reasonable doubt, because this is really an administrative process. It's meant to be facilitative instead of preventing the conduct of business between the bank and those it lends to. And so if we went the criminal way, then we'll become too rigid and nothing will move. And people will find it difficult, entities will, especially small ones, of availing themselves of these very important funds. So that's, I think, what informed that standard of proof. The third sanction that the Sanctions Office or Sanctions Commissioner renders is what we call conditional non-debarment, so that you don't bar the sanctioned entity, but you issue certain conditions that will save it from being debarred. But the most punitive one is debarment, so that this entity is debarred from participating in any bank-financed or administered projects for a period of years, for a term of years. The more aggravating, the more grave the sanctionable practice, the more serious the sanctioned period. So we range from 1 year debarment, 2 years, 3 years, and even 4 years debarment. And as I indicated earlier, the decision of the Sanctions Commissioner is appealable to the Sanctions Appeals Board. So far, since the establishment of the Sanctions Office 2012, we have had 13 appeals to the Sanctions Appeals Board. During my tenure, we've had only 2 so far. I hope we won't have some more. What the Appeals Board does is to thoroughly re-evaluate, again, the evidence. In this case, all the 13, the Sanctions Appeals Board upheld the decisions of the Sanctions Commissioner, but reduced, almost invariably, reduced the sanctions, the period of debarment. I remember one I had reduced, because PIAC had suggested 4 years, I reduced it to 3 years. The Sanctions Appeals Board reduced it to 2 years. So basically there has been, I think, concurrence between the Sanctions Commissioners and then the Sanctions Appeals Board. The challenges, quite quickly, one is the structure of that office. Actually, technically speaking, it is a one-man or one-woman sanctions office. And you remember the tribunal, there are many, the Sanctions Appeals Board, there are many, they have presidents, they have deans, but a sanctions commissioner is just that. What he or she has is an alternate commissioner. Basically, where the sanctions commissioner proper is from an English-speaking country, then the alternate will be from a French-speaking country, or maybe Portuguese, but non-English speaking. And these two do not work together. If, in fact, an FOSP is rendered in French, it directly goes to the alternate sanctions commissioner without reference to the commissioner proper. Same, if it is rendered in English, it goes to the sanctions commissioner proper without reference to the alternate. So this is an office that wields a lot, really serious punitive power. Absolutely. But it's a one-man, one-woman, technically speaking, institution. And it is only supported by one secretary. The secretariat is one secretary plus any 1 or 2 people that he or she may employ upon the approval of the senior vice president to support the secretariat work. And yet the processing of documentation is really heavy. That's, I think, a challenge. It's a structural problem which has to be addressed. I think that where an appeal from a sanctions office is determined by 3 board members, it is only fair that the sanctions office also should be empowered so that there is consultation across the board. As it is now, I have to rely on my judgment, because at the Supreme Court, we sit in a group of 5, and before we render a decision, it goes to and fro. Here, you have just to say, I hope those 3 wise men or women will see what I'm saying. And finally, I think each of us has been saying we serve an institution that is independent, which is true. The sanctions office is independent. But I think that the doctrine of independence has been taken too far in that institution, such that we seem to be working in silos. For 10 years after the sanctions system was established, there had never been a meeting until, I think this year, last year, October, when the various institutions came together to just share their experiences.
But maybe, Chief Justice, I assume that each year, each one of your institutions have like an annual report to the board and the president, where you will highlight your activities, your challenges, and some of the issues that you raise. Because I think the representative of the president is hearing here again that what you're saying is very important, because you're saying your office plays an important role.
Yes.
And should I say it is not only an important role, because as you see, the sanction, you're sanctioning people who otherwise have access under normal circumstances to a judicial system of their country.
Yes.
In which they are guaranteed due process.
Right.
So are you sure they enjoy the same due process before you as they would have had they been brought before the national court?
I think they enjoy better due process before me, because the procedure is very friendly to these entities. They are given enough time to respond to the allegations by PIAC. They are given enough time to put in evidence that may change the the Sanctions Commissioner's conclusions. They have an appeal process, and I think due process is not an issue to me.
Oh, it's very. Yes. So I'm really pleased to hear, and I think for the audience, you should also, because this is really important, because obviously this is just Chief Justice of Kenya saying, in his opinion, the due process at the bank vis-a-vis this company is as good, if not better, than what would you have. So that's fantastic. I think you should applaud for this. And management should be proud to put in place a system where somebody would say something. I'm very proud to hear that. And thank you very much. Now, let me move to David. You run an institution called IRM. Explain what it is, what they do.
Yes, thanks, moderator. And I have to say now, I think I'm all that stands between you and cocktails, and more importantly, my cocktails. So I'll try and kind of put this into some element in terms of a mandate. So what we do, as the name kind of implies, is one of the independent, but it's a recourse mechanism providing. What we aim to do is provide independent, effective recourse for individuals, for workers, and for communities who may be impacted adversely by a bank finance project. And this is right across the stream, so all of the kind of financing that happens. Now, where it's difference here in terms of this panel is that all of our stuff is going to be external. So we face kind of external operations side. So it takes us really into the Wild West in some areas. And so we don't necessarily have some of the same safety safeguards in some ways that you would have set up in that way too.
Yes, let me just follow. I mean, obviously it's very important, and it was in place by my predecessor, and but I always ask this question: you basically allow even one individual, if that person believes that she or he is adversely affected by the project of the bank, can ask that the independent expert to review.
Yeah, I mean, there is a process to go through, and obviously most or all bank projects should have a grievance mechanism at the local level. That's the first part and obviously from our view also, it's the most sustainable place that we want, disputes to be settled at the local level. Sort this out. Only after a certain time or period or good faith efforts is what we would constitute them, have been tried at that level, then they may escalate them up to our level. But we're not going to differentiate in terms of whether it's 1 or whether it's 100. And that's also in terms of what may be at stake. In some ways, it might be something that's a very serious issue that affects an individual. But it's an issue of kind of, you know, justice now, too.
But tell me, why don't they just, if they think, I mean, any citizen in a country that is being aggrieved by something or somebody, they go to the tribunal. They have, in a country that respect rule of law, which is the case of all African countries, why don't they just go why don't they sue the government or the private sector entity? Why should they sue the bank? I mean, the bank doesn't implement the project, it just gives the money to somebody.
So they don't sue the bank, and I'll leave that question back for privileges and immunities, but the office that we have is a direct response, as other offices have been, to that questions of privileges and immunities. But the question is in terms of, well, can they sue others, whether they be project implementers or whether they be borrowers, private sector, or whatnot. Absolutely, they always have that right, and certainly we would say that's a fundamental human right. For them to have. And we can run what are known as kind of parallel processes. And so in some cases, we have had complainants who will lodge a complaint with the courts and will also sometimes seek to remedy through our system as well. Now, our system also allows for both an investigation, but also can be a kind of ADR, a dispute resolution mechanism as well.
Absolutely.
And so they have those areas. Now, in those cases where they say, have they lodged a complaint in the court, we may, again, suggest what good faith efforts may be for you to suspend your court action in order to show good faith that you're ready to go forward with in a positive way in a mediation.
Perfect, thank you very much. Can you briefly, in 1 minute, say how effective you believe the IRM has been?
So maybe this is picking up on a question that Justice Theron was talking as well. First of all, I think it's not a question for us or for any kind of independent party to necessarily, it's really within the eyes of the beholder. So we make a big point of going out, and so we are conducting those evaluations to say, what do you think of those areas? Is this accessible to you? Is it predictable for you? Is it legitimate? And because if we lose that currency, then we become what any of us potentially up here on the stage could be, is what I would determine as a kind of ethical wall art. It looks really nice and we hang it, and you see that all sorts of code of conduct or wherever you might want to see. But if it doesn't actually do anything, then people are going to stop using it, right? And so I think that's, we're seeing more and more people use our services, which I think that's also an element. We can either say that there's more complaints coming and that's a problem, or we can say this is actually a successful thing that we can take forward in that area as well.
Thank you very much. So now let me ask if maybe 1 or 2 questions from the audience, if you want to ask to the tribunal or the appeals committee or the IRM.
You've got 3 minutes and 30 seconds to ask it.
Yes, madam. But state your name and who you are addressing the question.
Thank you very much. I am Sonia really happy to hear who is responsible for what, or maybe the internal evaluation. There is a broader question that most of the institutions we've been working with on the particular topic we've been dealing with is illicit financial flows and asset recovery. We've been told that the outcome of one of the work of the sanction commissioners was to these fines that were settled by the sanction of all entities has been put in a fund that is called the Affordability Fund about 10 years ago, and it's a growing controversy as to why it has not been operationalized, because somehow most of the institutions that are really looking for independent funding.
We have only 2 minutes, ma'am.
Yeah.
So just ask the question, then we'll have an opportunity. Yeah.
Integrity and financial transparency are not receiving a response from the fund. So is there any operationalization of the IF foreseen?
Thank you.
That's a responsibility of the board, I guess.
Thank you. Thank you. Any other question? And that will be the last one. Otherwise, then I'll give the floor briefly to David and then have a concluding remark. David? Because, David, do you? It was to the, I thought it was about the IRM. Okay.
It's true that the fines that were meted out, the money is about now about 18 million unit of accounts and still counting. Initially was supposed to be deposited into the Africa Integrity Fund. But recently, because of the controversies you make reference to, and following a recommendation by management of the bank, the board of directors has actually abolished that fund, and it has been replaced by an independent administrator of the fund. As recently as, I think, 14th May, the terms of reference for that independent administrator were issued by the president of the bank. So that is where we are now. So from the fund to an independent administrator. I hope what informs that is the need to address those controversies.
Thank you. So basically we come to the conclusion of this session. I have to recognize that it has been very informative, and thank you very much, President, and thank you, Justice Theron, thank you, Chief Justice Mangala, Barrister. It was fantastic to have exchanged with you, David. I think we should give him a floor. Thank you. Thank you all.